A federal court just handed the Justice Department a brutal loss in one of the biggest gun rights fights in America. And if you think this only affects marijuana users, you may be missing a legal shift that could hit gun law across the whole country. Quick question before we continue. Are you subscribed yet? If not, you could miss the kind of update that changes what counts as legal overnight. Hit that button now because this case is bigger than most people realize. Here's what just happened. On August 20th, 2025, the 11th U.S. Circuit Court of Appeals ruled against the Justice Department in a major gun case out of Florida. The case involved a federal law, 18 U.S.C. section 922G3. That law says an unlawful user of a controlled substance cannot possess a firearm. In simple English, if the federal government says your drug use is illegal, federal law says you cannot legally have a gun. Now, this is where it gets interesting. The people challenging the law were not cartel members. They were not violent criminals. They were Florida residents using medical marijuana under state law. Florida legalized medical marijuana back in 2016. These plaintiffs argued that applying the federal gun ban to them violated the Second Amendment. The appeals court did not fully strike down the law for everyone in America, but it did say these Florida plaintiffs had plausibly shown that the ban, as applied to them, could be unconstitutional. That is a huge deal. Let me break this down for you. First thing, this was a defeat for the DOJ because the court rejected the government's attempt to end the case early. A lower court had dismissed the challenge. The Justice Department wanted that dismissal to stay in place, but the 11th Circuit reversed that result and sent the case back down for more proceedings. That means the plaintiffs are still alive in court, and the DOJ did not get the clean win it wanted. Second, the appeals court said the government had not shown, at least at this stage, that disarming these medical marijuana users fit America's historical tradition of gun regulation. That history test comes from the Supreme Court's 2022 Bruen decision. Ever since Bruen, gun cases have turned on one basic question. Is the modern gun law close enough to how America regulated firearms in the past? If the answer is no, the law is in trouble. Third, the court focused on something most people miss. These plaintiffs had not been convicted of crimes. According to the reporting on the case, the court noted they had at most committed a federal misdemeanor by using marijuana, and the record did not show they were dangerous just because they were in Florida's medical marijuana program. And here's the part nobody's talking about enough. The Justice Department tried to compare these plaintiffs to groups that were historically disarmed, like dangerous people or convicted felons. But the court was not buying that comparison at this stage. The panel basically said, slow down. You cannot just slap the word dangerous on every medical marijuana user and call it a day. Think about what that means for you. Have you ever wondered why two laws can both seem real but point in opposite directions? Florida says medical marijuana can be legal under state rules. Federal law still says marijuana is illegal. And then federal gun law steps in and says if you are an unlawful drug user, you cannot have a gun. So a person can follow state law and still walk into a federal trap. That's what makes this case so explosive. Imagine you are a law-abiding gun owner in a state with medical marijuana. Your doctor signs off. The state issues the card. You never commit a violent act. You never threaten anyone. You just assume that because your state says yes, you are safe. But federal law may say no, and that is where lives get wrecked. Most people think state approval solves everything. The truth is, federal law can still control the outcome. If you're finding this helpful, imagine what you'll learn in my next video about the exact words on federal gun forms that trip up honest gun owners. Subscribe so you don't miss it. Now let's talk about why this loss hit the DOJ so hard. The government's main argument was simple. It said there is a long tradition of keeping guns away from people seen as dangerous, and that drug users can fit that category. The DOJ also argued that laws disarming felons support the modern ban. Sounds strong at first, right? But here's the crazy part. The appeals court looked at the actual facts in front of it and said the government had not done enough. The judges said the record showed only that these people were part of Florida's medical marijuana program. The record did not show how often each person used marijuana. It did not show that they handled guns while high. It did not show a pattern of violence. It did not show the kind of danger the government was talking about. That matters a lot because courts do not just decide gun cases based on fear. They decide them based on evidence, history, and how closely the law fits the facts. The 11th Circuit also rejected a broad claim from the DOJ that these plaintiffs were outside the people protected by the Second Amendment because they were not law-abiding. That sounds like legal jargon, so let me translate it. The government was trying to say these people do not fully count when it comes to Second Amendment protection. The court was not persuaded. It pointed out that they had not been convicted of crimes and had, at most, committed a misdemeanor by possessing personal use marijuana. This is the part that shocked me. The court treated the right to keep and bear arms as something the government cannot take away with a broad label alone. In other words, the DOJ could not just say drug user equals no gun rights and expect the judges to nod along. And there is another layer here. The plaintiffs also pointed to something called the Rohrabacher-Farr Amendment. That is a federal budget rider that limits DOJ spending to interfere with state medical marijuana programs. Now, don't make this mistake. That does not automatically mean every medical marijuana user can own a gun under federal law. Even the lower court had rejected that broader reading. But it shows how messy this area has become. One part of federal law limits how far DOJ can go against state medical marijuana systems. Another part of federal law says unlawful drug users cannot have guns. So people get stuck in the middle. Here's a hypothetical example to explain this. Let's say a veteran in Florida uses medical marijuana under state law for chronic pain. He owns a firearm for home defense. He believes he is doing everything right because he followed state procedures. Then he tries to buy another gun, answers a federal form the wrong way, or becomes part of a federal investigation. Suddenly, he is not dealing with state policy anymore. He is dealing with federal criminal law. If you don't know that line exists, here's what could happen. You could rely on state permission and still face federal trouble. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. But wait, there's something even more important. This Florida case is not happening in a vacuum. It sits right in the middle of a much bigger national fight over Section 922G3, the federal ban on gun possession by unlawful drug users. Other courts have been wrestling with the same issue. In fact, the 11th Circuit's reasoning was consistent with another major case out of the 5th Circuit involving marijuana and gun possession. That brings us to the real reason this case is high stakes. The Supreme Court heard arguments on March 2nd, 2026 in United States versus Hemeny, another case involving the same federal drug user gun ban. That means the biggest court in the country is now looking straight at this issue. So when the DOJ lost in Florida, it was not just a local setback. It was another warning sign that this federal law is on shaky ground in at least some situations. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who stay ahead of these rulings before the news twists them beyond recognition. Click subscribe. Let me explain why that should matter to every gun owner, even if you have never touched marijuana in your life. First, this case is about more than weed. It is about how far the government can go when it creates categories of people who lose gun rights. If courts demand tighter proof, better history, and narrower rules, that could affect future challenges in other gun cases too. Second, this case shows how dangerous it is to trust headlines. Some people will hear about this ruling and think, great, medical marijuana users can all own guns now. That is not what the court said. The 11th Circuit did not create a nationwide free pass. It revived a challenge and said the plaintiffs had a plausible constitutional claim. The case still had to go back for more proceedings. Other people will hear the same ruling and say, this changes nothing. That is wrong too. When a federal appeals court tells the DOJ that it failed to justify a gun restriction at this stage, that is a serious crack in the government's position. Third, this ruling shows why details matter more than politics. The judges on the panel were not all wild anti-government rebels. According to the reporting, the opinion was written by Judge Elizabeth Branch and joined by Judges Robert Luck and Gerald Chioflat. The point is not party labels. The point is that courts are applying the Bruen history test in ways the DOJ cannot always control. Here's what most people get wrong. They think every gun law challenge is about whether guns are good or bad. That is not how these cases work. Courts ask narrower questions. Does the Constitution cover the conduct? If yes, can the government show a strong historical tradition for the restriction? In this case, the plaintiffs cleared the first hurdle, and the DOJ did not win the second one at the motion to dismiss stage. And that wording matters, at the motion to dismiss stage. That means this was still an early part of the case. The government might still fight on. More evidence might come in. The facts could get sharper. But as of that ruling, the DOJ took a real loss. Now, this is where it gets personal for you. If you are a gun owner, you cannot afford to live by assumptions. you need to know whether your conduct is legal under state law, federal law, or both. Because when those two systems clash, it is not your favorite politician who pays the price. It is you. Imagine a traffic stop. Imagine a home search tied to some unrelated issue. Imagine a background check question you answer casually because you think your state card protects you. That is how ordinary people get dragged into federal gun cases, not always through evil intent, sometimes through confusion. And confusion is everywhere right now. The Supreme Court's Bruen ruling changed the legal map. Rahimi added another piece. And now cases like the Florida medical marijuana challenge and Hemini are pushing the courts to answer a hard question. Can the government disarm people based on drug use when the history is thin and the facts do not show immediate danger? That question is not small. It goes to the heart of how modern gun law survives after Bruen. This information could literally expire after the next major Supreme Court ruling. Subscribe now because the next video explains exactly what to watch for when the court finally speaks on this issue. So here's the bottom line. The DOJ suffered a real defeat when the 11th Circuit revived the challenge by Florida medical marijuana users to the federal gun ban in Section 922G3. The court said the government had not shown at that stage that disarming those plaintiffs matched the nation's historical tradition of firearm regulation. That does not mean the fight is over. It means the fight just got more serious. If you remember one thing from this video, remember this. State approval does not always protect you from federal gun law, and federal gun law is being tested harder than ever in court. Stay sharp, stay informed, and never assume a legal gray area is safe just because someone online says it is. If this helped you make sense of a messy case, subscribe and stick with me because these rulings move fast and the consequences are very real. And one final reminder in simple terms, this video is for education only, not personal legal advice. If your rights, your record, or your freedom is on the line, talk to a qualified attorney before you make any decision.